All attendees are in listen-only mode.
Good morning, everybody. We're going to get started in about half a minute, give some folks who have registered a chance to settle in and log on. Get started shortly. All right. Good morning or good afternoon, depending on where you are. My name is Mary Laplante. I'm Vice President of Client Services for Digital Clarity Group, and it's my pleasure to be part of this conversation about the GDPR and what it means for your business. Is this law the end of marketing as we know it, or will it be the catalyst for unprecedented innovation in consumer-brand relationships? Some housekeeping details before we get started. Our webinar today is being recorded. The replay will be available later today. You'll receive a follow-up email with the link so that you can share DCG's analysis with colleagues and executives. We will be answering questions at the end of our prepared remarks, but you don't have to wait till the end to submit your questions. Please enter them in the questions window on your GoToWebinar control panel. We'll take them as time permits, and if we don't get to yours, we'll contact you personally to follow up. The hashtag for today's webinar, which you'll see in a moment at the bottom of the slides, is hashtag #GetReadyForGDPR. My colleague Tim Walters, co-founder and principal analyst at Digital Clarity Group, is driving today's discussion. Tim is our thought leader for privacy and personal data security in general, and on the GDPR in particular. Hi, Tim.
Hi, Mary. It's great to be here.
Indeed. So, Tim, let's get started with learning a little bit more about our audience today. I think we have a poll set up, and what we'd like to know is ask our attendees to take just a second to indicate what their current knowledge of the GDPR is. So if those of you who have logged on can make a selection here based on your current knowledge, that would be great. Tim, I think that'll help us understand whether we have a sophisticated audience or whether we've got some folks who need the basics.
Exactly.
And I can't see the progress that we're making, but I'm assuming folks are...
I've got an indication that it's for attendees only, so I can't even participate in our own poll.
I know, exactly. Well, maybe we should move on to the presentation then.
Yeah, let's bring up the results and see what people said.
Oh, poll's still in progress.
Okay.
Great.
Oh, interesting. Okay. So I'll review these. So what's a GDPR? That is barely even knowing what the acronym might stand for, 35%, so well over a third. Some vague understanding, about half, so that's what, 82% have vague understanding or less. Another 12% general idea of what it means for my firm, and 6% who are going to torture me in the question and answer period because they're confident that they already understand it. And no one knows it backwards and forwards, and I think that I would be astonished if anybody answered that question in the affirmative, including myself or anybody in the EU who helped formulate the GDPR. So this is exactly why we're here, to help people advance their vague or limited understanding.
Great. Okay.
So
thanks, everybody.
Am I still in full screen mode?
There we go. We need, yeah.
There we go. Okay. Mary, you should see the About Us slide.
Great. Okay, thanks. For those of you who are not familiar with Digital Clarity Group, we are a research and advisory firm that helps organizations deliver world-class experiences to prospects, customers, employees, students, donors, citizens, depending on their audiences. Our focus is on the content, technologies, and practices that enable customer experience management. The use of an individual's personal data to drive satisfaction interactions is fundamental to engagement across all stages of his or her relationship with the organization, which means that helping our clients understand and respond to environmental factors like the GDPR is part of our mission. As for the topics that we'll cover today, we're going to explain the GDPR with the aim of helping you understand why you and your organization must be prepared to respond. We'll look at if and how this consumer protection law may spell the end of marketing as we know it. You'll notice there's a question mark behind that. Tim will highlight the key provisions and restrictions. We'll close with guidance on developing a GDPR game plan for your organization, and as I mentioned earlier, we'll take questions as time permits. Okay, Tim, I think you're going to get us started here with about the GDPR.
Exactly. So GDPR stands for the General Data Protection Regulation, although I'm pretty sure that many marketers and others will soon, if they haven't already, conclude that it stands for something else that begins with G and D, and probably something stronger than gosh darn. In fact, the Interactive Advertising Bureau, the IAB, has called the GDPR a draconian, blunt instrument approach to data protection. And another commentator said that the GDPR effectively places an incendiary or an explosive into the plumbing of internet advertising, one that cannot be disarmed by juridical location, as we'll see, legal opinion, or lobbying. So after 4 years of negotiations, it was ratified by the EU Parliament, and it is now set to take effect on May 25th, 2018, and I write the date here in the European style because you're going to have to get used to following European standards. So May 25th, 2018, nearly 2 years from now, you might say, but the answer is no, merely 2 years from now. Everyone unanimously agrees that EU firms should have started planning the response to the GDPR already many months ago, and I believe that the same is true for many, many non-European organizations, if not virtually all of them. Why? Because the GDPR is in no way geographically restricted to EU-based firms only. You do not need to have operations, offices, personnel, or anything else in the EU in order to be affected directly and deeply by the GDPR. It is not geographically defined or delimited as it's not geographically defined or restricted, rather it's geographically defined as legislating over the personal data of any EU resident. So that means that it has international, extraterritorial reach and scope. It applies to any organization, commercial or otherwise, governmental organizations, nonprofits, etc., that processes the personal data about any EU data subject, and we'll get to some of these definitions in a moment. So any organization that processes the personal data of any EU subject in conjunction with either offering them goods and services or what's called monitoring their behavior. So in effect, as soon as a company reaches into the EU to interact with a resident in one of these two ways, then the GDPR reaches out to dictate how they need to handle any personal data.
Okay, so there's a lot of stuff packed into those couple of sentences there. The one that stands out for me initially is monitoring.
Yeah, exactly. Right.
What does that mean?
Offering goods and services seems pretty straightforward. You're trying to sell them something. But monitoring, so take a look at this. Monitoring specifically includes the tracking of individuals online to create profiles, and now quoting the regulation, in particular to analyze or predict aspects concerning that person's preferences, interest, reliability, behavior, location, or movements. Now, what does that sound like?
Well, I think that's how many of our audience from the marketing side would define a best practice for digital marketing.
Exactly. Monitoring for preferences, interest, behavior,
Right,
and location, for example.
right.
So, but let's see how the GDPR begins to, if it does, restrict these kinds of practices. So, um, before I get into more definitions, I want to, however, splash some icy cold water in the faces of our audience by talking about what happens if you violate the GDPR. So here's, I say like Switzerland and speeding tickets, because as you may know, if you get caught speeding in Switzerland, they fine you not according to some set table of, $100 for 20 miles over the speed limit. They charge you according to how much money you earn, and there are instances of people being fined more than €1 million for a speeding ticket in Switzerland because they happen to be extremely wealthy. So that's the situation with the GDPR as well, probably because the EU has had a lot of experience with wealthy firms like Google and Microsoft and Facebook and Uber, in fact, that can just laugh off €10,000 or multi-100,000 euro fines. In this case, they've equipped the GDPR with some very, very sharp teeth. So fines are intended to be effective and dissuasive, and that's quoting the regulation. That means the fines are meant to hurt. They're meant to be painful so that the organization does not want to go through that experience again. So for the highest level of violations, the fines are 20 million euros or 4% of global turnover, whichever is greater. So just take a second to calculate 4% of your company's worldwide gross revenue. In the case that, in 1 year, your 2015 gross revenue for your company, 4% of that. In the case of Google, that's about $3 billion, not million, $3 billion. In short, the fines from the GDPR could be life-threatening for many companies. So if you need a way to get your colleagues and executives to pay attention to the GDPR and what it means for your organization, that's a good place to start. Okay, now as you start reading about the GDPR, or even if you dig into the 260-page document itself, it's available in 24 languages, by the way, there are some key terms that need to be clarified, even if you're just reading the articles and reports about the GDPR. So let me go through a few of those to kind of make sure we're on the same page. So a data subject is just a person, a natural person. It's an identified or identifiable natural person. Personal data is basically anything that allows that person to be identified, either directly or indirectly. Now note that the definition includes location data and online identifiers. And that means that in contrast to the 1995 Data Protection Directive that the GDPR replaces, it leaps directly into the digital age. So it includes under the definition of personal data things like cookies on a browser, or IP addresses, or mobile device IDs. Now, ultimately, what does or doesn't count as personal data is going to be one of those areas where there will be further discussion by the regulators and or by the courts, both before and, well, certainly after, maybe even before it goes into effect. But suffice to say that the definition is much broader than most companies are currently used to dealing with in terms of what counts as personal data. And the Interactive Advertising Bureau, in fact, and other industry lobbying groups lobbied very, very hard to have online identifiers like browser settings and IP addresses excluded from the final version of the regulation for obvious reasons, and they were unable to do so. And in addition, the GDPR also defines a set of special categories of data like race, political affiliation, religious affiliation, and so forth, that require even more stringent control, such as biometric and genetic data that might be used against someone effectively. Secondly, the regulation speaks frequently, incessantly, about the data controller and the data processor. And the controller, as you see here, is a person or a body that determines the purposes and means of the processing of the data. And the processor, in turn, carries out the processing. Now, obviously, these could be one and the same organization. They need not at all be two different parts. Thirdly, and probably most important, what is data processing? That's the key question. So I'm going to read this mostly verbatim, but I think this is the last time we'll have to deal with an extended piece of legalese from the regulation. Processing means any operation or set of operations that is performed on personal data, whether or not by automated means, such as, now pay attention, collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use, disclosure by transmission, sounds like emailing, dissemination or otherwise making available, alignment, combination, restriction, etc., and destruction, erasure or destruction. So in short, virtually any operation that can be carried out on a data set, including storage, that is merely having it in your possession, counts as data processing and makes the agent or the operator who carries out that operation a data processor under the terms of the GDPR. So again, if I send you an Excel spreadsheet with personal data in it, like names, addresses, telephone numbers, email addresses, I have processed the data by sending it to you, that is by disclosure by transmission, and you have processed it by having it. That's how far-reaching this is, and how far it and how many organizations are going to have to think about how they handle or refuse to handle personal data, given the limitations on it and the fines associated with it under the GDPR.
So in about 10 minutes, we've painted a pretty complex picture here. There's the mythology that it only matters if you have a business located in the European Union. Not true. This is at the level of a resident. There is possession of data. There's monitoring of data. There's the fact that there's the practical application once this is actually in practice that will probably answer some of the big questions. There's the requirement for granularity here. So I think, we can begin to see that the impacts on the marketers and the way they handle data is pretty astonishing, actually, once you take it all in. And it's easy to see that some marketers and other folks who are responsible for owning their customers, managing their customers' data, might think this is, in fact, the end of the world.
It might be, but in order to get closer to answering that question, let me ask you, Mary, can I borrow your car?
Well, Tim, you're a trustworthy guy, but you're in Berlin and I'm in Pittsburgh, and so that might be a little bit difficult, but let's say it was possible.
All right, so I show up at your house, I ask to borrow your car. What kind of information would you want to know in order to make a decision about whether you should loan me your car?
Well, again, I'm pretty sure that you're trustworthy. You live in my neighborhood. I've seen you around. But I'd still need to know a couple of things. What do you plan to do with my car? And, when are you going to return it?
Yeah, at minimum, I think. And those are completely reasonable
right.
questions, right? So I tell you, my car's broken down. It's in the garage. I need to take my mother to a doctor's appointment. It's 20 miles away, and I'll bring your car back by noon. Okay? And you say, okay, fine, no problem. But what happens if I don't come back at noon? I don't come back until 9 p.m., and it turns out that I've driven your car not 20 miles, but 200 miles, and in the meantime, I stopped and filled up the trunk with manure to fertilize my garden.
Well, let me tell you this, Tim. You wouldn't be borrowing my car again, and I might actually be in a position to take you to court over some of these damages that have been caused to my precious vehicle.
Exactly. Taking to court is the key thing here, and as well you should. So, in fact, I use this analogy because there's a whole set of mostly unspoken social and interpersonal and kind of quasi-legal mores and understandings that govern this common exchange, like borrowing someone's car. For example, to extend it a little further, while I have your car that I have borrowed from you, I certainly shouldn't act like it is now my car. I wouldn't loan it to yet another person. I certainly wouldn't sell it to another person. And what's more, I'm probably going to be anxious about something happening to your car while I have it. Someone scratches it in a parking lot, or someone steals it, or there's a hailstorm and it gets damaged. So I'm actually motivated to get rid of it as soon as possible. I want to get it back to you as soon as I can when I'm done with it, when I'm done with the task for which I borrowed it, because I don't any longer want to be responsible for it.
Okay, that makes sense.
Right. Now, I think it's fair and useful to think about the GDPR in this way. That is, the GDPR encourages firms to think of the acquisition and the use, the processing, and the destruction of personal data in a way that's very similar to how we've just been describing borrowing and using and returning personal property like a car. Now, the analogy isn't 100% perfect because, for one thing, the GDPR doesn't literally ascribe property rights to personal data, but for all practical purposes, it requires that personal data be treated as if it were a highly valuable piece of property like a car. So I ask the audience, does that sound like the way that you currently treat personal data in your organization and for your marketing purposes? Now, of course, every one of our listeners, or each one of their firms, that is, no doubt handles data differently. So rather than constructing a straw man of some kind to represent the world of data-driven marketing as we know it, I'm rather going to invite each listener to just think about how these key provisions of the GDPR that we're now going to review will limit or affect, or maybe even potentially enrich, your current or planned marketing and advertising and broader customer experience strategies.
Okay. Tim, while you catch your breath, I think this is a good point. We've planned another poll here, another survey question, and we'd like to ask our audience to select their primary organizational role from a list that'll pop up on the screen here. So we'll take a few seconds for that and look at the results once they come in. And Tim, even though I said you could catch your breath here, I am going to ask you a question. Because this is data and because every business is driven by data these days, through digital interactions or holistic interactions that we capture offline when someone's in a store, it would be fair to say that the impact on an organization isn't just in the marketing department.
Oh yeah, absolutely, and we'll see that very clearly in near the end of the presentation, and that's exactly why we're asking people about their primary organizational role, because it does definitely reach beyond marketing, and this is a firm-wide response to the restrictions and the benefits of the GDPR.
Right, right. It sounds scary right now, but as we say, and I think as you'll point out later on, you know, there's an opportunity for positive response here, even though it's a little scary in the beginning.
Yep.
So let's see. Poll in progress.
Okay. Okay, interesting. So 40% marketing or customer experience primarily, another 10% otherwise related with content creation or content management, probably websites and mobile sites mostly. 20% from IT, probably one or two people from risk compliance, and then a good 25% other. It'd be very interesting to know what those others were, but that's a good spread. So that's
Right.
useful information, and we'll come back to that in a moment.
Right. I think that reinforces the fact that the impact is cross-organizational.
Exactly. Okay. So I'm not advancing. Oh, now I got it. Okay, ask that question. Okay, let me go into some of the provisions or key kind of areas that you need to be aware of and start to deal with. So, consent. Under the GDPR, you must obtain what's called unambiguous consent for the collection and use of personal data. So specifically, this means consent must be freely given, specific, informed, and unambiguous. That means consent may no longer be implicit. It may not be assumed until the consumer opts out. It may not be based on pre-ticked boxes. Silence or inactivity may not be taken to imply consent. And finally, and I think this is really significant, you may not offer services that are contingent on consent to in order to use the service, right? So, for example, I think that means that you may not offer services that are contingent on consent to data collection unless it's necessary to carry out a contract. So, if I'm offering an online personal shopper service, I'm obviously going to need to know a lot about you in order to pick out clothing that you like and that fits you and so on and so forth. So in that case, carrying out the contract depends upon your consent to giving me a great deal of personal data. However, a service like online search, and Google and other search functions, they can work perfectly well without collecting any data about me. And I believe that means that Google, in fact, must, by May 25th or sooner, ask every one of us whether we consent to having them collect our personal data in order to use the search engine. And they are not allowed to deny us the service if we say they may no longer collect personal data. That's the impact on some of the common services that we're surrounded by in the internet today. Second, the stipulation that consent is specific means that it must be solicited and granted for each desired data processing operation. You can't issue a general or bundled, or what the regulation calls an omnibus request for data processing. If you intend to collect the data for more than one purpose, each purpose has to be spelled out in the request, and the response mechanism, such as a web form, must allow granular choice. That is, it must be possible for the consumer to provide or withhold consent for each one of the uses separately. And you can't say, if you don't agree to all of these, then you don't get anything. It has to be granular. And finally, consent has to be as easy to withdraw as it is to grant. And it has to be withdrawable by the same mechanism. That is, if it was granted via a web form on the website homepage, for example, a withdraw consent link should be prominently displayed there as well. So again, going back to our analogy, as when borrowing a car, you need to say precisely what it is you want and precisely how you intend to use it, and then use it only for that purpose. Now, hopefully as well, you're able to say precisely what benefit the consumer will receive in exchange for providing their personal data in order to motivate the consent. The regulation doesn't talk too much about that innovative side or that that accentuation of the relationship with the consumer, but that's the kind of thing that you want to start thinking about.
So that's a fascinating but complex picture of how the dynamic between the owner of the data, that is you and me, and the firms that we may desire to allow to use that. I mean, this sort of paints a really different picture. So when you talk about the value that you and I will receive in exchange, it begins to sound like the GDPR might create or enable something like a marketplace for personal data, where consumers themselves can barter and exchange for the best deals. So I've got coin of the realm in the digital era now.
Exactly. Yeah. I mean, it's this whole talk about a personal data economy and so forth. And we won't get into that very deeply today, but that's the bright side of the GDPR. But before we begin to even admit there's a light at the end of the tunnel, let me continue depressing people for a little bit with some of the other provisions or restrictions. So I realize we're running over time here for our half an hour, so I'm going to speed up a little bit, but hopefully you can stick with us. So when you ask for consent, the GDPR requires that the request must be conveyed in a concise, transparent, intelligible, easily accessible way in clear and plain language. That is, in other words, it's pretty much must be the opposite of your current terms and conditions or your current privacy policy, which are usually purposefully written in order not to be understood and not to be in clear and in plain language. Today's T's and C's are purposefully opaque and obscure and obtuse. PayPal's T's and C's are longer than Shakespeare's Hamlet. And hilariously, the passage of the GDPR itself that spells out the need for information to be provided in a concise form takes up 6 full pages in the regulation. So it's an open question who's going to write these transparent and accessible requests, since mostly organizations are now training people, whether they're the legal department or others, not to write them in precisely the other way.
Exactly. So a couple of things. It sounds like there'll be a constant rain of consent requests, which somehow have to be both comprehensive yet concise and transparent. But once a firm has legitimately collected all this within that constraint, what does the GDPR say about how they should handle it?
Yeah, exactly. So this will get to I think what is the kind of the heart of the matter, at least in a 30-minute presentation or so. So generally, digital marketing as it's evolved over the past 20 years, but especially in the last few years under the banner of big data, of course, has pursued what I would call maximum data or data maximization. That is, the rule is get as much data as you can directly from consumers through behavioral monitoring, from internal systems, buy it from third parties, and then figure out what to do with it. Right? Treat it as a corporate asset, extract as much value out of it as you can, that is, perform as many operations as you can, ring it as often as you can. As one marketer said to me discussing the GDPR, or rather the impact of current practices, we're going to get more personal data than you can possibly imagine, and we're going to use it in ways that even we haven't begun to dream about. And now you can already see how the GDPR requirements around consent and transparency pretty much clearly begin to undermine that approach. But it also takes it a giant step farther. That is, it requires that any use of data, that is, any data processing, adhere to the regulation's data protection principles. Whoops. So that means two things. First, unlike the way most of us as Americans treat the IRS tax code, for example, you cannot argue in the case of the GDPR that you follow the letter of the law and just happen to find some loopholes. You have to rather adhere to the spirit of the law, the principle of the law. And that principle is that you should protect and respect the sanctity of personal data. Every action has to be directed by an adherence to the principle of respect for personal data. Now keep in mind that in the EU Charter of Fundamental Rights, there is a right to the respect for private life and a right to the protection of personal data. So what that means is that in direct contrast to the practice of data maximization, that under the GDPR, you must, not only should you must strive for data minimization. So the GDPR characterizes this approach as what's called privacy by design and by default. And what that means is that you have to be able to demonstrate upon request, or in some cases, actually many cases, you have to be able to demonstrate in advance that you've designed a data processing system that does the following things. Sorry, I lost my page. The system that you've designed operates by acquiring consent as prescribed, as we described. It uses the smallest possible amount of personal data to achieve the desired effect. It uses personal data for the shortest possible period of time, and it deletes or stops using data as quickly as possible after the processing is completed. So again, I'm going to borrow your car for this specific purpose. I'm going to abuse it as little as possible, and I'm going to return it as fast as I possibly can. So accountability, in other words, is just inescapable under the GDPR. You cannot refuse to be accountable. It's not sufficient to react after the fact, like something happened and then you apologize and say that you'll never do it again. In fact, that kind of inattention to getting ready and following the requirements would call for the highest level of fines, 20 million euros or 4% of your revenue. Rather, you have to proactively design and build and operate and monitor an end-to-end system that corresponds to and ensures the core principles of data minimization and privacy by design are being observed. And I think it's important to take this quite literally. Compliance with privacy by design has to be comprehended and operated as a system. And just as the elements of a system must always work together to produce the desired outcome, all of the departments and roles and individuals must support the principles of privacy by design. This is why we asked about your primary role. The GDPR is not a problem for the legal department. It's not a problem for IT. It's not a problem for security and risk or marketing or the board of directors. It's a problem for all of them, and it requires a systematic strategic response.
So, you know, one of the teasing questions we titled our webinar, is this the end of marketing as we know it? Well, it sounds like actually it's not just the end of marketing as we know it, but it may be the end of sort of the end of the business world as we know it. It's the implications are far-reaching.
The implications are very far-reaching, but you know, I want to say a little bit about the bright side as we conclude here. However, there's one more important aspect that you need to know about. I mean, there are many more important aspects, but there's one in particular, and that is a principle called data portability. So it doesn't quite fit in with our borrowed car analogy, but it's completely in the spirit of the notion that my personal data belongs only and always to me, and I don't lose possession of it, and you don't get possession of it just by asking me if you can have it. The GDPR stipulates that I can, that is any data subject can, but I can at any time ask any company or organization for a complete report of my personal data that they hold. That means they need to know what all of the personal data of mine that they hold. And I doubt many organizations can even do that at this point. A complete and exhaustive report. This must be reported in a reasonable period of time, and you guessed it, it must be reported in a transparent and intelligible format. I can also direct that the company destroy all of my data that they hold. This is the so-called right to erasure, or the right to be forgotten. I can also ask for a copy of all of my data, and it has to be provided in what's called a common electronic format. And I can ask that it be given not to me, a copy of all of my data, or not a copy of all my data, all of my data can be given not to me, but I can ask that it be sent to another company, that is your competition. So I can say to my insurance company, say Allstate, pack up everything you know about me and my property that I have insured with you and send it to Farmers because I want to switch providers. Now that does, in short, data portability does for personal data what mobile number portability did for consumers and did to network operators. But that means that it opens up an entire new vector for competition, and therefore a new area for possible competitive advantage or disadvantage. And innovative companies will find ways to induce consumers to switch, not only their businesses, but also their potentially very rich data profiles. And if farmers can induce me to send my entire 30-year profile with Allstates to them, that enriches them and weakens Allstate well. So it becomes this incredibly new area for competition and competitive advantage. And if it is the end of the world, in other words, the GDPR is also the beginning of a brave new world, and you don't have a choice. You are entering this brave new world. But it's a brave new world where companies can design new services and new kinds of customer interactions and new business models that create and communicate mutual value, going back to your point about you being the kind of holder of the keys around your personal data.
Right.
So business models and services that create mutual value for both consumers and sellers, and they turn the blunt instrument of the GDPR into a kind of motor or fuel for new economic relationships.
Yeah, so wow, again, at the end of that part. In the few minutes that we have remaining here, Tim, what does this mean for our audience today? What should listeners start doing, once they recover from the fire hose that we delivered today?
Exactly. Okay, so here's a general game plan, and this is obviously very high level, but it goes something like this. First, awareness. So sound the alarm and get people's attention. The level of awareness in the U.S., interestingly enough, the level of awareness in the U.S. is not markedly less than it is in the EU, but it's still depressingly low in both cases. So you need to start getting people's attention to this. That, like I said, it's only less than 2 years before this takes full effect, and some parts of it will take effect sooner. Secondly, educate yourself. So there are many, many, many publications and forums and meetings and workshops. And as a matter of fact, Digital Clarity Group is offering a workshop on the GDPR. Formulate the appropriate kind of cross-departmental working group that's got the elements that need to be in there. Clearly, marketing, IT, legal, HR, very important. There are training requirements around GDPR about who can and can touch personal data and how what level of awareness and training they have to have in order to be able to do so. And then, as quickly as possible, and these things can be running in parallel, taking stock, that is a kind of audit on personal data. How is it currently being used? Where is it stored? It's probably being stored in some cases you don't even know about. how does it flow through the organization, or worse, not worse, but more problematically, outside of the organization? Can we identify all of an individual's data if we were to get that kind of request today? Like, tell me all the personal data that you have about me. Can we store consent forms? Most people don't really store consent in any way except for a kind of an on-off yes-no. But now you have to know exactly what you asked them, exactly for what purpose, what kind of granular consent they gave you, and all of that has to be reproducible at any time. So on and so forth. Then plot the roadmap from your current state business as usual to a GDPR compliant business within 2 years and 11 months. And finally, but by far not least of all, take it, keep looking at the bright side, as it were, of the GDPR. Investigate. I would put a lot of effort into investigating new ways to compete with and win with the GDPR. It opens up this personal data economy and a whole new world, really, of ways of thinking about business models and ways to engage with consumers. It could be extremely powerful for virtually any company if they can take advantage of them.
Right. Okay, some really good pieces of advice, sort of, to send our group off this afternoon. I do think, though, we'll take a question or two because we promised we would, but I also think we have a third poll that we'll put up here, Tim, maybe while we ask our audience to complete that one, and then maybe we can take this kind of first burning question. So given what you know now about the GDPR, maybe you could, our audience, if you could take a moment to guess what your likely impact on current marketing processes will be.
Mm-hmm.
So, Tim, while our audience addresses this question, we've got one here that wonders whether or not this is all about the European Union trying to rein in the power of the technology and data giants. Is this really about Facebook, Amazon, Google, the rest of them, and a control play here?
Yeah, that's a widespread belief. It might even be kind of a comforting story that marketers, especially in the EU, tell themselves at night so they can go to sleep. But it's not true, because the regulation applies equally to any firm, regardless of size. It can be a single person can be a substantial data processor for, can run the technology that processes a lot of data. So it can apply to a very small firm. And also, in fact, it's quite possible that the GDPR will be less of a burden for some of the data giants that you've talked about, let's say in particular Facebook and Amazon, because they have a direct relationship with the consumer. Their business is a direct relationship with the consumer. So they can generally demonstrate more easily that kind of mutual value exchange that we were talking about. Amazon, when you give your personal data to Amazon, like my credit card information and my primary mailing address, I get a clear benefit back from that, because now I'm able to buy something with literally one click. So I can see the benefit of giving them my data. But if your organization is removed 1 or 2 or 3 steps, like many ad tech companies are, for example, that nobody even knows that they're running in the background, then it's going to be much harder to explain to people why that kind of organization wants to collect their data and what kind of benefit they're going to be delivered from allowing that collection.
Right. Let's take a look. Do we have our poll results yet?
Okay. Very disruptive, requires rethinking our basic approach, and unsure, need time to raise awareness. So I don't want to lump those two together, but one very disruptive, one might be disruptive, but we need to find out. Substantial impact, but basic approach remains, and some manageable changes. Again, that would be, and again, no one thinks it's business as usual. Right. That's good. Again, it would be interesting to discuss with people those kinds of what counts as a manageable change and substantial impact. But we can see that basically the majority, by far, 67%, believe it's either very disruptive or could be disruptive, but they need to reflect and talk about it within the organization.
So we have a couple of I just want to clarify, a couple of folks have said that they'd like to have access to the replay. Yes, we're recording this session. In a follow-up email, we'll send you a link to the complete replay, including the audio and visual for today. So yes, replay will be available. And we have a couple of questions here, Tim, that circle around existing, current state here. So I'll distill these questions by saying, what impact does this regulation have on already collected data? Will companies have to delete all their customer data? Will it only come into effect if that data is transferred? How?
Yeah, that's a pretty complex situation. So, but I don't want to ignore the question entirely. Basically, there clearly are substantial changes in the GDPR and things in the ways that we've just discussed, and I've tried to hit on the ones that I think are the most impactful changes. But when you get right down to it, the GDPR does not fundamentally change the way the current EU regulations about personal data. And if you have collected data that followed the current guidelines under the so-called Directive of 1995, then in principle that should still be valid. That is, you collected it according to, in ways that, and you treat it in ways that are still within the guidelines of the GDPR. You may yet have to go back and get new consent because it's probable that your request for consent was not as clear as the GDPR requires, and that accordingly the consumer's assent to the request, the granting of the consent, did not fit within the GDPR's new definition of unambiguous consent. But so that's what I would say. If you collected it in ways that were currently observing the EU's current regulations that have been in place since 1995, then you shouldn't have to just get rid of it, but you may have to renew consent for it. If you collected it in other ways, it's very probable that you'll have to stop using it.
Right, great. We do have a couple of questions here that circle around impact in other parts of the world, notably in the U.S. So two folks have asked, do you see the United States ever adopting a similar regulation to this?
I do. I mean, I don't have a professionally informed opinion about that, but I can tell you that this notion of this kind of philosophy of privacy by design and default was actually formulated by a Canadian woman, I believe, who's been promoting this for a number of years, and the GDPR is the first kind of major piece of legislation that puts this privacy by design into action. And there's a lot of people believe that this will kind of be the first important trigger or accelerator for encouraging other countries or other legislative bodies to adopt similar kinds of legislation that's informed by privacy by design. That's one thing. Also, I've been to a couple of events around the GDPR here in Europe where representatives from the FTC or other government organizations within the United States spoke, and they say there that the GDPR is very much in accord, or is in principle in accord with the direction that they think they are currently moving as well. I wouldn't anticipate that the U.S. would probably, first of all, take act of Congress, not something by the FTC, to adopt something as broad as the GDPR, but something that has similar kind of effects, yes.
Yeah, but it's also, this goes back to the mythology here that if you don't have your headquarters in a European Union country, you don't have to worry about that. But we've tried to disperse that. So whether or not North America, Canada, U.S. has a similar law, if an organization collects the data from one resident in an EU country, the regulations apply, right?
Exactly. Yep.
Yeah. Okay. We are 20 minutes over. We do have a couple of other questions, but I think in the interest of folks who joined us expecting 30 minutes, we'll probably wrap it up today, and we will get back to you with those answers. Here's contact information for both Tim and me. If you have any questions that go above and beyond the material that we've presented today, we'd be happy to speak with you directly about other questions you might have or how we can help. At least two of the questions, Tim, had to do with how this spills over outside of marketing internally within an organization. So that kind of goes back to one of your game plan points, which is, you know, for everybody on the call, the most useful thing to do is go back to your organizations today, make a list of your stakeholders in a GDPR challenge,
Yeah.
and get those people around the conference table ASAP.
Yeah, exactly. That's it.
Yep. So thanks everybody for joining us. We really appreciate it. We'll follow up later today with a link to the replay. And again, contact Tim or me if you have any questions. Thanks for joining us.
Thank you.